Welcome back, everyone. Let's get right into it. I've gotten a lot of comments recently talking about qualified immunity was just revised. Let's check out this video from Lehto's Law. This guy makes videos regarding law. He's very good. I've actually watched a couple of his videos. So make sure you guys go subscribe to this channel as well. Let's get right into it.
Here's Steve Lehto.
Qualified immunity is probably the most technical thing that people ask me to speak about. I get requests, Steve, please talk about qualified immunity. And, it's an interesting topic, and it's one of these things that when people hear about it, they go, what? No way. So let me tell you first what qualified immunity is, okay? The definition, qualified immunity, is a special protection for government officials that the U.S. Supreme Court created in 1982 with judicial policymaking.
It was not created in 1982. It was created a couple years after the Jim Crow laws were repealed. It was revised in 82, folks.
A statute, the legislature didn't get together and make a law. This is something that the Supreme Court just invented. By default, all government officials are immune from liability if they violate.
Hold on. Let me break this down to you guys. Qualified immunity was enacted a couple years after the Jim Crow laws were repealed. And what happened there was a pastor went to a whites-only cafe in Mississippi, or a coffee shop or whatnot. And he was asked to leave. He didn't leave. He was arrested and he was convicted. They took it to the Supreme Court. And in order to not hold the state judge and the chief of police or the sheriff or whatever, to hold him personally accountable, the judge gave qualified immunity throughout the land. So that's what I know from qualified immunity. Yes, it was revised in 82, but it was enacted in 67, I think. And I will put a link to what I know in the video as well, guys. Let's keep watching.
Your rights. Whether your rights were actually violated doesn't matter. Under qualified immunity, government officials can only be held accountable for violating someone's rights if a court has previously ruled that it was clearly established that those precise actions were unconstitutional. So if no such decision exists, or it exists but in another jurisdiction, the official is immune, meaning you cannot sue them, even if they acted intentionally and knew they were breaking the law. So the weird part about this is it creates this weird vortex of nothing, because if you file a lawsuit and say this officer violated my rights, they say, okay, specifically what are your clearly established rights? And you tell them, and they say, okay, can you show us a case in this jurisdiction on point? And you go, well, no, I can't. And they say, okay, and they throw it out. Someone else comes along a year later with the exact same facts and says, I'd like to sue that. Has any court ever ruled in favor of this on these clearly established facts? No, they haven't. Okay, throw it out. And so it'll never be clearly established because they get thrown out the first time. And people notice that almost immediately. And it's like almost like I hate to talk about this because I'm going to get some computer guys mad at me, but in computer code, where you just have a weird loop that just, and somebody would immediately look at it and go, oh, there's a problem right there. Fix that, right? And a lot of attorneys back in 1982, when this ruling came down, said, wait, this is going to cause a weird problem because no court's ever going to say these are clearly established with no basis. Therefore, they'll never become clearly established. So it looks like the Supreme Court may have just turned around on this one. Erwin Chemerinsky is a legal scholar. He wrote a column for the ABA Journal, and it's a very good one. He says SCOTUS hands down a rare civil rights victory on qualified immunity. So here's a case that made it to the U.S. Supreme Court. And it got there because lower courts were throwing it out saying qualified immunity, qualified immunity. So it's a per curiam decision, meaning the Supreme Court simply just handed it down. It doesn't say it's authored by this justice and the other ones concur and so on and so forth. Per curiam. But it was handed down without briefing and without oral argument. So apparently they looked at the pleadings and said, we don't need to hear oral argument. We don't need to see the briefs. Because they can look at the pleadings in the lower court and just say, we see what's going on here and it's wrong. So this one did not get much attention. And Chemerinsky says, it's understandable that this might have been overlooked even by civil rights attorneys. But the case is significant because it is a rare instance in which the high court rejected a claim of qualified immunity and made it clear that no case on point is required in order to hold a government officer liable. So here we are almost 40 years later, and the court is clarifying a ruling from 1982, and they're saying, oh, by the way, that was not necessary in these other cases. So It's impossible to know if this is an aberration, because these are extreme facts you'll hear in a second, or it might be the beginning of a new, more civil rights-friendly approach by the Supreme Court. A victory in the Supreme Court for a civil rights plaintiff in qualified immunity case is notable and could matter in lower court litigation. So the facts of this case, Taylor versus Riojas, has shocking and disturbing facts. Taylor is a prisoner in Texas who entered a psychiatric prison unit to receive mental health treatment following a suicide attempt. For a period of 6 days, he was confined in a pair of what the court rightly described as shockingly unsanitary cells. Court explained that the first cell was covered nearly floor to ceiling in massive amounts of feces on the floor, the ceiling, the windows, the walls, and even packed inside the water faucet. For 4 days, Taylor did not eat or drink for fear that he might get sick doing so. He was then moved to a very cold cell with only a clogged drain in the floor to use as his facilities, if you know what I'm talking about. The court said that the drain eventually overflowed. Raw sewage spilled across the floor, but because he didn't have a bunk, he had to sleep on the floor naked because he had no clothing either. He later sued the corrections officers, alleging they violated his Eighth Amendment rights by inflicting cruel and unusual punishment. The district court ruled in favor of the defendants based on qualified immunity, holding they could not be held liable because they did not violate clearly established law that every reasonable officer should know. How should a reasonable officer know that it's wrong to put a person in a cell like that for that length of time? Because no courts ever specifically ruled and said it was wrong. And if no courts ever specifically ruled, how would they know? How would they ever?
And it just makes me wonder how many times correctional officers in prisons have done this to people along the way, cruel and unusual punishment. And why is it that only now things are starting to get pointed out? I know, like, these people have made mistakes, and a lot of people are in prison for whatever reason. Many people are probably in prison for bullshit laws. You guys know that. But nevertheless, you would believe that in America we would treat our prisoners humanely.
Know that. United States Court of Appeals to the Fifth Circuit affirmed, of course. Court of Appeals ruled that Taylor's constitutional rights were violated. Being placed in these cells was cruel and unusual, but it also concluded that the officers were protected by qualified immunity. They said that the officers could not be held liable that because the law wasn't clearly established that prisoners couldn't be housed in cells teeming with human waste for only 6 days. Now, the High Court's decision is 7-1 because Justice Clarence Thomas dissented, although I believe all he simply wrote was Justice Thomas dissents, no opinion. And Justice Amy Coney Barrett was not participating, so you get 7-1. That's why you get 8 instead of 9. The court reversed the Fifth Circuit. In the opinion, the court held that the officers were not protected by qualified immunity because no reasonable correctional officer could have concluded that under the extreme circumstances of this case, it was constitutionally permissible to house Taylor in such deplorably unsanitary conditions for such an extended period of time. The court said, confronted with the particularly egregious facts of this case, any reasonable officer should have realized that Taylor's conditions of confinement offended the Constitution. Thomas did not write an opinion. Like I said, he simply wrote, Justice Thomas dissents. So this matters. And again, this is Erwin Chemerinsky writing. Any government officer sued for money damages for allegedly violating the Constitution has an immunity defense. Some are protected by absolute immunity, such as judges for things they do on the bench, prosecutors for things they do as a prosecutor, law enforcement personnel for their testimony, and things like that. So it makes sense that you can't go into court and go, I don't like the way the judge ruled against me, I'm going to sue him personally. Okay? So that type of immunity makes sense. It's the immunity we're talking about that says, oh, by the way, when they're doing other stuff that's discretionary.
Wait a minute. I don't think that I agree with absolute immunity being okay. That just means that, yes, judges are going to rule according to their opinions, but what if their opinion is backed by money or special interest? That becomes an issue and that becomes a problem. And the person is left hung out to dry while these people are creating this bubble, and it's protected. It's called absolute immunity.
and they're clearly violating somebody's rights, they don't get this qualified immunity that was invented by the Supreme Court almost 40 years ago. To point out, Steve, did the Supreme Court really just say that there must be clearly established precedent, and yet the actual qualified immunity ruling was just made up out of thin air? So why is it that we can invent a legal doctrine out of thin air with no precedent that actually says these people here need precedent that can never exist? It's mind-boggling, and I'm not laughing at the result. I'm laughing.
Steve Lehto is explaining to you guys what I've been talking about, what I've been feeling, that it just doesn't make any sense. Qualified immunity. I've been talking about this for over 2 years. I first heard the Batu side talk about it, and I jumped on it because I understood it. For 2 years, I've been reaching out to, say, for instance, Sean King, and sending him comments and trying to see if he'll address this qualified immunity, only to be ignored. And when I went out there to protest the first day during the George Floyd incident, I went and spoke to a news anchor, and I talked to him about qualified immunity. Somebody tagged my video. Somebody tagged Sean King in my video, and the very next day he posted end qualified immunity right after Bernie Sanders did, because they tagged Bernie Sanders too. Am I saying that my video caused Bernie Sanders and Sean King to open up their eyes regarding qualified immunity? I don't know, but I will say this. The very next day, they stopped talking about it, they stopped posting it, and they started posting defund the police. Qualified immunity was never in their interest to take it away. They don't understand police accountability like some of us do. We're in this. I personally am in this to win this for you, the people. When you have guys like that who have some kind of special interest in mind, they're not in it for you. They're not teaching you to teach the kids how to record police. They're not teaching you how to know your rights and know your human rights and why the Constitution was written. It was written to protect your human rights and to limit the scope of authority of government. Keep paying attention, folks.
At the logic of it. And an entire generation of law students has studied this and said, this is strange. It's bizarre. So in case after case, the Supreme Court found officers were protected by qualified immunity under this standard.
And what about this, guys? What about the lawyers? What about the lawyers that take your money and they tell you we can sue, we can sue, we can sue, we can sue. You're going to get money, you're going to get money, you're going to get money. But they know that the officer's going to get off on qualified immunity. You didn't know that. The lawyer did, the cop did, the judge did. The lawyer took your money and you lost.
Since passage of qualified immunity, the court has dealt with it in 30 cases. The plaintiffs prevailed in only 2, one in 2002 and one in 2004. Thus, the court's ruling in Taylor versus Riojas for the plaintiff and denying qualified immunity is notable in itself. But the court's reasoning also is potentially quite significant. So it's not just that they ruled, but it's the explanation. The court, in its opinion, relies on 2 prior decisions. These are the rare cases where the court said that there does not have to be a prior decision on point to overcome qualified immunity. One of them is a case called Lanier in 1997. Was not a civil suit under 1983, but rather was a criminal prosecution under 18 U.S.C. 242. Now that's a section of the law, the Civil Rights Act. The former creates civil liability, the latter criminal liability for those acting under color of state law who deprive a person of rights protected by the Constitution. So it's interesting that this hasn't gotten more attention. It will now, because like I said, Erwin Chemerinsky is a well-known legal scholar. In fact, I printed off his bio here because it's important. Chemerinsky is a dean of the University of California at Berkeley School of Law. He is an expert in constitutional law, federal practice, civil rights, and civil liberties, and appellate litigation. The author of several...
Does that make me an expert on law? I've been talking about qualified immunity for 2 years now. Leave it in the comment section. Am I an expert? I'll tell you guys this right now. I am not an expert. I have more questions than answers, and I'm trying to figure it out. Let's keep watching.
Books, including the case against the Supreme Court, and a couple others that he's written for large publishers like Oxford University Press and so on. But obviously being the dean of the Berkeley School of Law at University of California is a big deal. So this could be the beginning of the end for qualified immunity, because the Supreme Court has said that you do not need to clear that impossibly high hurdle of finding another case in your jurisdiction that shows that what you are alleging was clearly established to be wrong in another case. Well, if you can't find that case, you don't win, so your case gets thrown out and goes right on the pile of all the other cases that got thrown out, because you got to have the first case that establishes those rights clearly established.
And call me crazy, but somehow I believe that all those cases that were thrown out for qualified immunity should go back and be looked at to give those families some type of justice. I know it'd be hard and it'd be costly, but that's what America's about. Justice. Give those family members justice of their family members who were killed, or their rights were just simply violated.
And if the case doesn't exist, it never will. So that was a strange thing about it. People go, why is it qualified? I don't know, because it looked like absolute immunity, but they couldn't call it that because that's already being used by the stuff that everybody else gets. So qualified immunity was invented by the court in 1982. They just said, well, we think this is right. And it's, unusual because most people assume that the Supreme Court tries to follow precedent or tries to, simply redefine things. But this is one of those.
And this is what I keep talking about. This is what I think Steve Lehto is missing. And let me break this down really quick for you guys. And I don't want to take anything away from Steve Lehto. I think he's a brilliant man, and he's trying to bring the educational value of law to his channel and to all of us. So with that, I want to say thank you to Steve, but I will say this, okay? Qualified immunity was not enacted in 1982. It was enacted in 1967, and it was enacted over a racist law. That's why I'm saying I reached out to Sean King and these guys. Maybe I was dumb for doing so, just to be ignored. But look, qualified immunity was enacted over a racist case. Why BLM didn't jump on this is mind-blowing. It's beyond me. I don't comprehend or understand why ignore it. Why aren't you trying to teach your youth? I'm trying to teach mine. And as a matter of fact, I'm trying to teach yours too, because you're failing. You failed them. You failed them. Shame on you.
Examples where the Supreme Court simply created something out of whole cloth, as they say, and it's a form of judicial policymaking or judicial activism, take your pick, but it created this weird situation where the police or other government actors could do outrageous things that they knew were wrong. They could admit it was wrong, but you still can't sue us for it. And so this could be the end, and I hope it is. I hope it is. So, again, it's Erwin Chemerinsky, an article for the ABA Journal. SCOTUS has handed down a rare civil rights victory on qualified immunity, and the case is Taylor versus Riojas. So there you go. Could be good news. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Steve, thank you so much for doing this video, man. I will also be doing follow-up videos regarding qualified immunity. Like I said, I've been talking about it for 2 years, only to be ignored. And those videos didn't take off nowhere. I guess nobody knew what the hell qualified immunity was, and nobody knew what the hell I was talking about. Well, a lot of you guys do. We haven't shut up about it. We've been going on about it, yada, 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 nonstop. And now we're beginning to understand it. I really appreciate the ruling from the Supreme Court. And Steve Lehto, thank you. And let's really focus on this. And let's make sure that we get rid of qualified immunity for good. And we don't need to have this umbrella over the police, allowing them to do whatever they want. It's an unsustainable system. We can no longer keep going down this road. If we the people need to be held accountable, then we the people in uniform also need to be held accountable as well. Or the world just isn't going to work. With that being said, thank you guys for tuning in. I'll see you on the next video. Have a great day.